Civil rights are paramount to living a decent and happy life within the realms of human society. Any infringement of these rights leads to people being marginalized, mistreated, and discriminated against. In today's video, we will discuss one act that upholds the rights of those looking to seek housing. History of the Act. The Civil Rights Act of 1968 was signed into law by US President Lyndon B. Johnson amid the riots following the killing of Martin Luther King Jr. The Indian Civil Rights Act, which covers Titles 2 through 7, pertains to Native American tribes in the United States and makes many, but not all, of the Bill of Rights provisions applicable within the tribes. The Fair Housing Act, which covers Titles 7 through 9, was enacted as a follow-up to the Civil Rights Act of 1964. A brief description of the Act. The Fair Housing Act, passed in 1968, forbids discrimination based on race, skin color, sex, nationality, or religion during the purchase, sale, rental, or financing of housing, whether it's for private or public occupation. The law has been changed multiple times, most recently in 1988, when disability and family status were added. In some jurisdictions, state and municipal regulations may enhance these safeguards, but they may not diminish or weaken them. Title 8 of the Civil Rights Act of 1968 is the official title of the Fair Housing Act. Understanding the Act. The Fair Housing Act is enforced by the U.S. Department of Housing and Urban Development, or the HUD for short. In the 1950s and 1960s, Congress passed the Civil Rights Act in response to the fight to remove racial segregation and injustice. The Fair Housing Act was passed by the American Congress shortly after the unfortunate killing of the Reverend Dr. Martin Luther King Jr. This act was the last of three great pieces of legislation that were enacted during the civil rights movement. The Fair Housing Act was expanded by the federal government in 1974 to add gender rights, then in 1988 to include protections for families with children and individuals with disabilities. Specific protections for sexual orientation and other categories have been implemented by several state and local jurisdictions in the recent past. In some cities, such as New York, a bank or landlord cannot inquire about a person's criminal history. Discrimination on the basis of immigrant status or authorized occupation is likewise prohibited in New York City. Racial discrimination laws have been expanded to encompass ethnic hairstyles such as dreadlocks, as well as other superficial characteristics. What housing discrimination actually looks like? Here are a few good real-life examples of common types of discrimination related to housing that can occur to those unfortunate enough to face them. Number 5. A real estate agent refuses to show a customer a house for sale in a certain neighborhood because of the buyer's race, religion, or ethnicity, or, on the other hand, guides a buyer to a different neighborhood when they ask to see a property in the same price range elsewhere. Number 4. A modern multifamily condominium failed to meet accessibility rules for buildings built after 1991, preventing a wheelchair-bound buyer from accessing a unit or parking. Number 3. When a potential renter calls to inquire about an apartment over the phone, the landlord claims the unit is available. But when the individual who inquired is African American, the landlord says the apartment has already been rented. The landlord responds that it is now available after receiving a call from someone of a different race. Number 2. Because of their sex, color, or nationality, a mortgage lender charges a borrower a higher interest rate for a loan to buy a property in a predominantly Latin neighborhood than in a predominantly white district, or pushes a consumer to a loan with less favorable terms. Number 1. A single woman with children is refused an apartment by a leasing agent. Enforcing this act, the U.S. Department of Justice, DOJ for short, may launch a lawsuit against someone accused of engaging in a pattern or practice of discrimination or for discriminating against a group of individuals to the point that an issue of wide public concern is raised and acknowledged by the U.S. Attorney General under the Fair Housing Act. If there is a common recurrence or observable pattern of discrimination in mortgage loans or renovation-related loans, the Department of Justice can put forth a lawsuit under the Fair Housing Act if a denial of rights to a group creates an issue of general public concern. If force or the threat of force is used to discriminate, the DOJ can bring criminal charges. Persons who have been discriminated against can file a discrimination complaint with HUD or sue in federal or state court. On the basis of recommendations from HUD, the DOJ files lawsuits on behalf of the individuals. If someone files a complaint with HUD, the department is supposed to look into it right away. If conciliation fails to resolve the particular complaint, HUD determines probable grounds to suspect if federal laws were broken. The HUD prepares a charge of discrimination if it finds a reasonable cause. Either the person alleging the discrimination or the respondent has 30 days to decide whether the accusation should be tried in federal court or in an HUD administrative law court. Some states and municipal governments also go above and beyond federal fair housing rules to give additional fair housing protections. For example, the New York State human rights law includes protections against discrimination based on creed, national origin, sexual orientation, gender identity or expression, military status, age, lawful source of income, in addition to the Federal Fair Housing Act. A shortcoming of this act, according to housing and civil rights attorneys, demonstrating housing discrimination is difficult unless it is overt and evident, and that gathering excellent evidence in the form of written records and papers is helpful. Individuals who fear that they've been discriminated against should seek advice from their local fair housing center or an attorney. Latest updates: the LGBTQ community and COVID-19. Following are the updates pertaining to the LGBTQ and COVID-19 pandemic within the Fair Housing Act by the 117th Congress in their resolution passed on 4th of April 2021. Whereas fair housing testing has revealed that discrimination on the basis of sexual orientation and gender identity exists, and that fair housing protections must be extended to the lesbian, gay, bisexual, transgender and queer LGBTQ+ community. Whereas same-sex couples are 73% more likely to be denied a home mortgage compared to heterosexual couples, and when same-sex couples are approved, they pay an average of $86 million more in combined annual interest and fees. Whereas while our nation has made great strides in eliminating housing discrimination, families with children, women, people with disabilities, people of color, religious minorities, immigrants, LGBTQ+ individuals, and low-income people receiving public assistance, among others, still face discriminatory barriers to housing. Whereas amid a global health and economic crisis, housing discrimination against healthcare workers and persons who have been infected by COVID-19 or are perceived as having been infected is contributing to increased evictions and hate crimes. Whereas systemic health and economic disparities are exacerbated by the COVID-19 pandemic, disproportionately infecting communities of color, destabilizing their employment opportunities, and resulting in higher levels of evictions and foreclosures. Whereas amidst the COVID-19 pandemic, harmful sentiments towards Asian American and Pacific Islander communities have incited increases in racialized and gendered violence across the nation. Whereas reports of sexual harassment have increased by 300% during the COVID-19 pandemic, with incidents disproportionately being reported by women of color and transgender women. Whereas persons with disabilities must have equal access to online, telephone, print, and all other mediums of housing information, notices, and resources during the COVID-19 pandemic to prevent predatory and discriminatory housing and lending practices. Whereas persons with disabilities, including seniors and children with disabilities, have experienced unlawful denials of their reasonable accommodation requests to insulate them from exposure to COVID-19 and its associated life-threatening complications. To conclude, the path to justice is long, and freedom is a daily battle. As activists who fought for civil rights legislation in the 1960s noted, it has been 50 years since the Fair Housing Act was passed, and while the nation has made significant progress, there is still much more to be done. The fight to eliminate housing discrimination must continue because everyone deserves equal access to a secure, decent, and affordable home. Before we go, here are some important takeaways. Number 4. The Fair Housing Act prohibits landlords, sellers, and lenders from discriminating against home tenants and buyers based on their race, color, religion, sexual orientation, nationality, disability, or family status. Number 3. The Department of Housing and Urban Development is in charge of enforcing the Act at the federal level, HUD. Number 2. State laws can strengthen but not weaken the Fair Housing Act's provisions. Number 1. Discrimination in housing still exists, although it can be difficult to prove. Winning a court case necessitates meticulous documentation and perseverance. Hope you enjoyed this more educational type of video. Tell us in the comment section below what other law-related topics you would like for us to cover next. Have a good one.